That is 8.37. Justice Matthew. All this your lordships have seen, if lordship comes to see. In fact, I may read A also at page 27. If, as held in Mahendralal Jaini's case, the word void in Article 13(1)(2) had the same meaning, it was difficult to understand why a pre-constitution law violating Article 19 should remain operative against non-citizens after the commencement of the Constitution, and a similar post-constitution law should not remain operative against non-citizens. The fact that the pre-constitution law was valid when enacted was irrelevant in its continuing to operate against non-citizens, notwithstanding the provision of Article 13(1) of the Constitution came into force. The real reason why the law remained operative was that only the law became void under 13(1), which took away or abridged the fundamental rights under Part 3, and since Article 19(1) does not confer any fundamental rights on non-citizens, such a law remained operative against non-citizens. If so, a similar post-constitutional law would also remain operative against non-citizens. Rights do not exist in vacuum, they must inhere in some person, natural or juridical, and under Part 3, they inhere even in fluctuating bodies like religious denominations. See, the scheme underlying 13(1) and 13(2) is the same. Article 13(1) makes a pre-constitutional law to the extent of its inconsistency with fundamental rights. Article 13(2) makes a post-constitutional law void to the extent of its contravention of fundamental rights. In both cases, the law remains operative with non-citizens because Article 19 does not confer any fundamental rights on non-citizens. The voidness is not in them, but to the extent only of inconsistency or contravention. Therefore, void in Article 13(2) can only mean void as against persons whose fundamental rights are taken away or abridged by law. The law might be stillborn so far as the person, entities, or denominations, those fundamental rights are taken away or abridged, but there is no reason why this law should be void or stillborn as against those who have no such rights. So, even according to the learned author, in part it is stillborn, which is a theory which your lordship will have to test in some case. In this case, doesn't require your lordship to go into all this. But since my learned friends have raised it, therefore only I am trying to demonstrate that these dictums and the debate is in the context of breach of Article 19 and in the context of a debate of citizen versus non-citizen.
Yeah.
So in some appropriate case, your lordship may go into all this, but in the present case, it's a case of incompetence, constituent incompetence, which may be considered to be akin to legislative incompetence, where all these cases, including the learned author, are at one, that in this case of incompetence, it is null and void, ab initio, beginning, as if it was not there at all, as if it had no effect. And in case of 368, it will be a case where the Constitution does not stand amended on account of Section 4.
Article 368(4) also was struck down because judicial review of the 42nd Amendment also was barred.
That's right.
That was also struck down
That's
in Minerva Mills.
yes.
Section 55.
Then they brought in separation of powers. And it is well settled, Lord. I will not trouble your lordships. In page 30 and 31, I have mentioned three cases. Your lordships have said that under the Constitution of India, there is no rigid separation of powers. Even this court makes rules of court, rules regarding to servants, etc. So there are some legislative functions. Then there is, as I said, the court makes judicially also makes law. Not in the way the parliament does, but through interpretation and declarations. Under 141.
Most of the
So
rules,
overlapping of functions.
Yes,
civil servants make most of the rules.
that's right. Most of the rules are made by them. So there's no rigid separation. Even in the matter of judiciary, notwithstanding that the fact that it is a basic feature of the constitution, still the salaries are fixed by parliament. There's so many things which parliament does with regard to the courts and judiciary. The legislatures do. So, so the separation of power doesn't really, the fact we don't, court doesn't need to repeal. So I will just draw your lordship, finally coming back to your lordship, just note at page 11, I go back, starting from Keshwanand, I go back to Keshavanand Bharti, and I place the 10 judges order which was finally passed in that case. I have extracted at page 11. And the direction number 2. Now kindly correlate this para 75, Chief Justice Y.V. Chandrachud uses the same expression, does not enable parliament. So the ability of parliament to introduce a bill is not there. The ability of parliament to pass that bill is not there. Such a bill, therefore, itself, section 4 being part of the bill, goes out. That ability is lacking. Now, this is something not there in 13.1, 13.2, so your lordship need not enter into that debate. And the next page I have quoted from the IR Polo's observation. The bold portions in 124 and 125. It would fall, last 4 lines of the bold portion in 125 would fall beyond the constituent power. And then at page 14 is para 75 of Minerva Mill, identical expression. Section 4 is beyond the amending power. Therefore void. So I'll just wind up Lord with giving to your lordships the 4 cases which I've list out Lord on the proper first part of it. On that first one, the first 2 cases are on material resources. That is 1992 Supplementary 1 SCC 692 Assam Sillimanite. Volume 5, page 2640 at 2654.
654.
Yes, ma'am. And the second is Jilu Bhai versus State of Gujarat, 1995 Supplementary 1 SCC 596, Volume 5, page 2676 at page 2700, para 29. The first one is para 34. They have said that material resource has to be construed widely. The third case is Jagannath versus authorized officer, that's 1971 2 SCC 893. 893 para 18 and 29
Volumes.
which is volume 2, annexure 7, volume 2N, annexure 7,
Page.
at page 184, 198. This is with regard to acquisition, which I said, no, it's part of the 39B. So this case directly holds that acquisition and distribution go together under 39B. And the last is, Lord, Pathuma's case 1978 2 SCC 1. Para 5 and 8, volume 2N, annexure 18. That's page 891 at 898 to 900. This is a case of that agricultural credit loans, agricultural debt, which was wiped out and upheld by a 7 judges bench of this court. So even that is a material resource upheld with reference to 39B. Yes,
Yes.
the Land Solicitor General has mentioned this case. I'm grateful.
Thank you, Mr. Bedi. Thank you.
I did not, my lord, assist. I'll take 5 minutes on that.
Yes.
Bro, please come to my submissions 2L, page 23. Just, my lord, I am highlighting because I see some, my lord, problem. Just I'm a word of, my lord, caution. My lord, the lordships are aware, as my lord, the 42, my lord, 2L, L for Lakshadweep, no 42. The lordships would be going into it. I'm just bringing to your lordship's notice without reading it that this is also one more angle.
2L.
2L, L.
There's no page 42 actually. There's no page.
223.
23.
Para 24, 42.
Yes.
Para 40. But sum and substance of the argument, which I, my lord, fully support and adopt, is that if there is a legislative incompetence declared by the court, then it goes. If it is held to be unconstitutional on the ground of violation of fundamental rights, it remains as a dead letter, my lord, according to them. But now there is one nuance which is not concerned. We are not concerned, but in some other matter, my lord, it might affect. One provision was declared unconstitutional under 14 and 19. It remained on the statute book. Therefore, my lord, the parliament removed that unconstitutionality which was based on 14 and 19, and that act is upheld by this honorable court. You must kindly bear one fact in mind. So, page 23, your lordship would find all this judgment. Lord, I am not going. Keshav Rao, Madhav Menon, Peshi Kaka, etc., etc., etc. But, my lord, Blackstone doctrine, my lord, I would, in just 3 minutes, my lord, I'll be able to, my lord, satisfy your lordships. And this is accepted with some addition by Indian jurisprudence. But since your lordships would be writing on this, it may not be, it should be complete. That's the purpose. But Blackstone doctrine, my lords are aware, says that if your lordship declares a law invalid on the ground of incompetence, constituent incompetence or legislative incompetence, it relates back to the date on which it was passed, and your lordship's declaration of unconstitutionality would mean it never existed. So that is the doctrine of, that is Blackstone doctrine. For the first time, it came to be considered by Indian court in Golaknath case. Lord, your lordships would find that, I'm not reading, my lord, but at para 47, page 25, Golaknath. Lord, Golaknath case Your Lordships accepted Blackstone doctrine with one exception. Since your Lordships have the power under 142, your Lordships decided that when we declare the law to be invalid, it would go to the root. It never existed. However, we have the power of prospective overruling. So if we say that it would be overruled from today onwards, then it would not relate back. But we are not concerned with that situation. But leave that, Lord. I am not reading the Golaknath case. Please come to, my Lord, page 27, para 51. I am just giving the citations. Lord, that is Jarnail Singh versus Lakshmi Narayan, where, my Lord, this Blackstone doctrine. Lord, why I am saying this? When section 4 of the Amendment Act is declared unconstitutional, it goes to the date on which it was made and it never existed. That is Blackstone doctrine. So whatever was there earlier remains. It's not revival. The section 4 never existed. Lord, then your Lordships would have para 52, CIT versus Saurashtra Kutch Stock Exchange Limited, 53, PV George versus State of Kerala, 54, Chandrasekhaya versus Jankiri. Then, my Lord, M.A. Murthy, this is, my Lord, a lead judgment on the point. Your Lordships can, my Lord, at your Lordship's leisure, go through it, para 55. Now, my Lord, come to page 30, para 56. Other jurisdictions have also accepted this doctrine. And that's what, Lord, I wanted your Lordships to, Lord, take note of, so that when, if your Lordship decides this question, it should be, our assistance should be complete. Therefore, Lord, that other jurisdictions also follow the same doctrine. I'm not reading, Lord. Harper versus Virginia Department of
Please
Taxation.
look at them, Mr.
Lord, this is a US. Lord, thereafter, next is Supreme Court of South Africa, para 57. Democratic Alliance versus Minister of Home Affairs, Lord, Supreme Court of Appeal of South Africa. Then, my Lord, Irish Supreme Court, my Lord, para 58. Then, Lord, Australian High Court of Australia, that's the highest court, Lord, 59. Then 60, Supreme Court of Canada in so-and-so versus so-and-so. I have quoted, my Lord, the relevant part. And, Lord, thereafter, again, my Lord, some judgments of our court, my Lords. So my respectful submission, my Lord, in cases where there is unconstitutionality declaration based on fundamental rights, it remains, but it can be cured by the Parliament. But if it is either lack of legislative competence or constituent competence, like in the present case, it goes, and in any case, alternatively, as per Blackstone doctrine, it never existed the moment Minerva judgment is delivered. So these are my submissions. But as, my Lord, I have assured your Lordships yesterday, I have put one pager, Lord, as page 2U, volume 2U. It's one page. It's just been mailed. I am not reading it. What is, my Lord, my interpretation of Article 39B? I have already, my Lord, made my submissions on that. But yesterday, my Lord, I sought your Lordship's permission to place that one pager. It is literally a one pager. Grateful.
Yes, Mr. Shankar.
Okay, so.
Before I address you on the points which I had put in my notes and I'd highlighted yesterday, I thought I'll just respond to a few things that took place this morning. First is with reference to Mr. Dwivedi's arguments on the higher standard. I adopt what he says about constitutional or constituent incompetence. But I'd go a step further and say that as far as the basic structure doctrine is concerned, that is the very ethos of the Constitution. That's the fundamental, the Grundnorm, as it were. I don't think there is the possibility of, in any way, limiting a violation to it. If we accept that a breach of the basic features have taken place, that cannot be tolerated by this court or by this country even for a minute. What I mean is that if therefore this court declares at any point of time that the basic structure has been violated, we cannot possibly consider a situation where that basic structure violation is permitted to have continued even for a short while. It means at its fundament that constitutional balance has been upset. So restoration to its very essence, to its very genesis, is a constitutional imperative. It is a mandate. I pitch it a little higher than what Mr. Dwivedi did, because a question of legislative incompetence may permit this court, particularly with its powers under 32 and 142, to at some point carve out remedies which may permit even a legislatively incompetent law to a certain extent to be saved for whatever purpose. But not so with the violation of the basic structure. Because if it's a basic structure violation, everything has to go in my view. It's absolutely fundamental. Linked to this is the fact that this prospective overruling doctrine, which Chief Justice Subbarao heavily relied upon in Goloknath, was a pre-basic structure situation. So there he did not have the advantage, though the arguments were made by Mr. Nambiar about implied limitations on the constituent power, which was not accepted. But subsequently, when Mr. Palkiwala argued it before the case on the bench, it succeeded. So prospective overruling, whether it is available to a constitutional amendment challenge after the basic structure doctrine, is not a question that's ever been explored. But I would say it is not available. It is not available for a constituent court to say that yes, our basic structure has been violated, but today when I am saying that that violation has taken place, I am going to save everything that took place from then till now, but not going forward.
So it goes to the root of the matter.
Absolutely goes to the root of the matter. Which is why, if you step back a bit, the way 31C stands today is that 39B and C doesn't upset the balance. But the minute on this side, apart from 39B and C, you put A, D, E, and then you put 38, 37, 30, 40, 41, etc., the balance goes. That's why Minerva Mills said, no, we can't send it that far. But maybe those two. But between those two subclauses of 39 and the entirety of Part 4, where does that balance stand? We don't know. It's not been explored. But it is because that balance gets completely upset that the basic structure is affected. Which is why I would say there is no question. It goes absolutely to the root of it and it cannot be permitted even for a moment. The second, I think, just to assist, because your lordships had put a question, is there an instance where a provision has been struck down and then the legislature has taken steps? It's happened at least once to our knowledge, which is in Indira Gandhi versus Raj Narayan, 329A was struck down, where they said the election of the Prime Minister cannot be questioned. But that was in 1975, in November 1975. But in 1979, the 44th Amendment omitted that provision completely. So that has happened at least once. I'm sure there might have been instances where it has come up again. And then I'm very grateful to Justice Bindal for highlighting the oversight which is entirely mine. The provisions which have in fact been struck down by the Constitution, at least in this version, we have put them all in italics, which includes the NJSC provisions. Part 9B, cooperative societies, because 368(2) proviso was not met. Everything there went except dealing with multi-state cooperative society or a competence issue. So we very carefully went through it and put it in italics. But your lordships are right. We omitted to do that with the Chandra Kumar provision. That's a correction that we need to do.
Not in your book only, it is there in the government publication.
No, that is there. It's there across publications. But I'm saying here, at least,
Question was how to sort it out.
No,
Whether
absolutely.
they are bound to do it, as you said,
No,
29
because
they deleted.
eventually, my lords, all authorities will say ignorance of the law is no excuse when it comes to a citizen. So the citizen has to know. Exactly. There has to be some possible, maybe some PIL will be brought before the court at some point.
Deem in this case, everybody is raising this.
Yes. Correct.
So if this solution is given immediately after the judgment, the deeming arguments are not required.
I would just say, suppose there was a review petition or a curative, and then that judgment was overturned. The poor draftsman will be going erasing and putting it back, erasing.
Not that immediately next day they have to take it.
No, I know, I agree, I agree. Or there may be an overruling at a later
Yes,
stage after.
a larger bench may say
Yes,
that the striking down was bad.
correct.
Therefore, it gets revived by
I-
a judicial verdict.
I think the discipline that the publishers follow effectively is that, look, if the legislature has done something, we leave it there. The courts have taken a decision, so we'll have to put a footnote or something.
Brother
Let's,
Bindal,
One,
not the Gopal Shankaranan, the senior counsel, but Gopal Shankaranan, the editor of the Constitution.
no, but we will carry out that correction. Well, it's, with reference to, I think, a very interesting remark that came from my Lord the Chief Justice, that what would happen if instead of saying part 4, each of the provisions were mentioned. That was in fact done. There were 2 amendments moved in the 44th amendment before Minerva Mills, but 2 private members had moved amendments suggesting not the entirety of part 4, but 37, 38, 39, and they mentioned 4 or 5 others. Now, it's very interesting because if that had come up and your lordships had struck that down, then perhaps I think it would be very valid to say that the provision has no meaning thereafter. Because you've listed 39 among those.
There you're right, completely.
But that's not what happened. And there they didn't even place those amendments finally for voting.
But they would have probably struck down everything but 39B and C.
See,
Because they were bound by Keshwanand.
it would
Perhaps-
remain.
They may have.
39B and C would have been,
Correct.
would have
In which case it would have been much
It was bound by the 13 judge judgment.
And
Yes.
doctrine of severability would have applied.
Clearly.
They
Correct.
would have saved that.
Correct, it would have saved that. Well, so now I'll just quickly go through 2 notes. I'm just telling you what my points are first. The 2 notes are 2E, E for extreme, not elephant, extreme, and then 2M, M for middle. So that's what the court is being called upon. 2E and 2M.
So you want us to accept 2M and discard 2E, or what is?
In a sense, so that we can have a balancing one. So I'll just explain what those 11 points are so that your lordships knows immediately what the sense of it. The first is with regard to the background of 31C. I think it's integral for us to understand the historical background as well. Nobody explains this better than Granville Austin in Working Democratic Constitution. Chapter 10, I think a very interesting reading about how these 3 constitutional amendments came together, 24, 25, 26, and what the aims were there. Interestingly, this 25th amendment was part of a set of amendments to get around R.C. Cooper, where 10:1, the nationalization of the banks had been rejected. Now, why this is interesting is, apart from bringing in 31(2) by section 2 of the 25th amendment, it brought in 31C by section 3 of the 31st amendment, of the 25th amendment. Now, all of these were subject matter of Keshananda eventually. But what is interesting is the 3 things that took place. The first is that on 10th Feb 1970 is when the judgment in Cooper takes place. On the 28th of October 1971, the Law Commission goes into the draft Constitution 25th Amendment Bill to understand exactly how much of it would be approved, would be worth it, etc., etc. The members of that commission are very interesting. It was chaired by former Chief Justice Gajendra Gadkar, but